Good afternoon, ladies and gentlemen. We're certainly glad to have all of y'all here at the Judiciary Committee. Let me talk to you for just a second. We've got a couple of public hearings. At public hearings, we're certainly going to hear from people who want to speak either in favor of or in opposition to a bill. We're going to do that. We're not going to take votes on those bills today. We're not going to take amendments to those bills today. We're just going to listen to what people have to say, and I think we're off next week. So in a couple of weeks, the two bills that we have a public hearing on, which is House Bill 32 and House Bill 165, it is my intention for them to be up for a vote, in a couple of weeks, and we'll take them up at that point in time. We've got a couple of bills, House Bill 104 from Representative Moore, House Bill 182 from Representative Lipscomb. House Bill 104 deals with its definition of sexual conduct, and I think they're still working on that. And House Bill 182, Representative Lipscomb, deals with removal of individuals from, if they're unauthorized to be on a piece of property. Again, they're dealing with that. So we will take those up in a couple of weeks also. With that, I think that's about all I've got to say. Go ahead and call the roll for me.
Hill.
Here.
Wadsworth.
Here.
England.
Here.
Almond. Bedsole.
Here.
Chestnut.
Here.
Faulkner.
Here.
McClammy. Pettis. Robbins. Simpson.
Here.
Standridge.
Here.
Starnes.
Here.
Stringer.
Here.
Tillman.
Here.
We have a quorum.
Okay, well, we got a quorum, and we're going to go forward. The first thing, Representative England, if you would just explain your bill, and then we're going to do the public hearing. You certainly may do that from there since you're inappropriately dressed for the committee, but that's fine.
Hey, Faulkner, you think I had on a purple, rose-colored, or burgundy corduroy jacket?
Go ahead, Mr. England.
I know that today is just for purposes of a public hearing, so I'm just going to give a brief explanation, and I'll be here in a couple of weeks to come back and answer any questions on the legislation. But essentially what it does is it amends the felony murder statute in the state of Alabama to appropriately punish the person that is the primary perpetrator in the offense, and to avoid the unintended consequence of someone who may not have been involved serving a inordinately long sentence. So that's essentially what it does. I think there are 6 people signed up, and I think they'll probably give more light to the reason why we are why I filed this bill, and I'm attempting to try to amend the felony murder statute. So without any delay, I'd much rather hear from those folks than hear from myself. So
thank you. Okay, we got 3 people that are going to speak as proponents of this, 3 in opposition. We're going to take them 1 proponent and then 1 in opposition. We'll flip them back and forth, 3 minutes each for each person to speak. So be thinking about what you're going to say, please, or I hope you already have. And Ms. Anderson, if you're ready, we're ready.
Good afternoon, Judge Hill and members of the committee. I thank you for the opportunity to speak with you today. My name is Akeisha Anderson, and I am an attorney who serves as the Policy and Advocacy Director for Alabama Arise. On behalf of 150 member organizations and over 1,500 individual members, I would like to thank Representative England for sponsoring this bill and the committee for considering it. Currently, Alabama is one of only 14 states that subscribe to the proximate cause theory when applying the felony murder rule. This is the minority approach across the country, as the vast majority of states subscribe to an agency theory instead. By passing HB 32, this committee will not only help to bring Alabama in line with most of the nation, but will also help to ensure a much fairer application of the law. Under the agency theory, which again is the majority rule, unless either the person committing the crime or the accomplice directly cause a death during commission of the underlying felony, there can be no felony murder. Thus, the misdeeds of a third-party actor is not ascribed to those who have committed the crime. Other states that have adopted the agency approach have cited several reasons for this. Of most concern to my members, the proximate cause theory too often leads to absurd and racially disparate results. Unfortunately, Black people are 3.5 times as likely as our white counterparts to be killed by the police. The fact that the felony murder rule often holds others responsible for police killings only exacerbates racial injustice in states like Alabama, where people can face felony murder charges when police kill their co-offenders, similar to what happened to Lakeith Smith, which you'll hear more about today. Within the 14 states that apply the proximate cause theory of felony murder, we too often see a pattern of prosecutors using such felony murder laws to shift blame from police to suspects, often Black suspects, for police violence. Although data is hard to come across in Alabama, we know that in states like Illinois, where the proximate cause theory was used until recently, that police officers were the shooter in more than half of the cases where someone was convicted under the felony murder rule. To be clear, getting rid of the overly broad application of the felony murder rule will not allow people who commit crimes to sidestep prosecution or consequences for the crimes that they do commit. It will simply ensure that they are not serving overly harsh and long prison sentences and are already unconstitutionally in overcrowded prisons for actions that they neither set in motion nor foresaw happening. Also, by ensuring that the law clearly enumerates what crimes can lead to a felony murder charge, we are ensuring that the application of the felony murder law is not applied to predicate offenses that have an extremely low risk of death, such as burglary of an empty home and drug law violations. Thank you for your time.
Sure, go ahead.
I'd like to know where you got your statistics that Black people are more like 3.5 times more than white people to be shot by police.
The Sentencing Project, and I can
tell you the stats right now that I'm looking at right now. In 2017, it was 458 white people, 222 Black people. In 2018, it was 459 white people, 228 Black people. In 2019, it was 424 white people, 251 Black people. In 2020, it was 459 white people, 243 Black people. In 2021, it was 446 white people, 233 Black people. In 2022, it was 389 white people, 225 Black people, and in 2023 it was 412 white people and 224 Black people. We can argue stats all day, but to sit there and come through and have officers be attacked in a public hearing for statistics that just aren't true is wrong.
I can get that report for you, like Representative Senseman from 2013 or 2023.
Okay, thank you, ma'am. Ms. Casey?
Good afternoon. I'm Pamela Casey, and from 2007 to 2011, I served as a prosecutor with the Alabama Attorney General's Office, and in 2011 was elected as District Attorney of Blount County, and I've held that position for almost 13 years. So I've been a prosecutor for pretty much my entire legal career. I really want to talk to you a little bit about what House Bill 32 does as it relates to punishment. What you may not realize about the bill is it moves felony murder from a Class A felony to a Class B felony. That is a problem for prosecutors. And why is it a problem? Well, if we look at Class A versus Class B, it comes down to sentencing. Okay, in a Class B, I'm looking at 2 to 20. But if you compare it to your good time bill that y'all passed last year, I could actually earn good time on a felony murder if you leave it at a Class B. So what does that mean? If you look at House Bill 32 as proposed to be passed, and you look at the different crimes, very few of those require an actual deadly weapon to be used in order for you to qualify for one of those crimes, to be charged under that felony. But if you look at the Nick Reisner Act, you will be eligible for good time unless a deadly weapon is used if it's a sentence of 15 years or less. So let's assume that you are convicted of felony murder if this bill passes, and you're tried to a jury of your peers, and you get a 15-year sentence, and no deadly weapon was used. You are eligible for good time. Good time for murder, because no deadly weapon was used. Now, what do I mean by that? I have someone that I'm prosecuting that participates in a rape one, and during the course of the rape, the individual or the lady dies, okay? No deadly weapon was used. Judge sentences this person to 15 years. They're eligible for potentially good time under the act. They're not ineligible because it's not a Class A anymore. If as written and you pass this on H. Bill 32 and it goes to be felony, you will be letting violent offenders back on the streets of the state of Alabama to re-offend. Thank you.
Good afternoon. My name is Bronchina Smith. I'm a longtime native of Alabama. I'm the mother of Lakeith Smith. In 2015, my 15-year-old son, Lakeith Smith, and some of his friends, including Dante Washington, were burglarized in unoccupied homes in Millbrook, Alabama. A neighbor saw them and called the police. When the police arrived, one of the officers shot and killed Dante Washington. However, my son and his friends were charged and later convicted of Dante's murder under the felony murder law, even though they did not intend to hurt anyone and did not hurt anyone. Yes, my son was committing a crime, and yes, he should be punished. And I feel like my son should be only held accountable for the crime that he did commit. This month marks 9 years that my son Lakeith has been incarcerated. He's been gone away from home since he was 15. He's now 25. My family and my community have fought for the past 9 years to get my son's sentence reduced, and now we're fighting to get my son home on time served. I support HB 32 because our current felony murder law is not just or fair. If HB 32 had been in effect in 2015, my son would have been only held accountable and received proper sentencing for the crime he and his friends actually committed, and not for the crimes of the actions of a third party. More importantly, he now would be at home with myself and our other family. Thank you.
Thank you, ma'am. Appreciate it. Mr. Casey.
My name is Matt Casey. I'm the District Attorney of Shelby County, Alabama, at the 18th Judicial Circuit. Thank you for your time today, ladies and gentlemen. I would like to point out that under this agency theory, what this would do, ladies and gentlemen, is that, for example, if Representative Bedsole and myself go in to rob a bank and he shoots a clerk, this bill would eliminate the ability for me to be held accountable for that. We go in together, we have a plan to go in and rob this bank, we're armed, we go in there to commit a robbery, and when you have guns and you rob people, bad things can happen. He shoots someone, I can't be held accountable for that. And we would certainly be opposed to that. We think that's a tool in the toolbox for DAs to use to hold people accountable for these things. Another thing I'd like to bring up is that, let's see, the language, it amends the language from, it actually eliminates the language of any felony clearly dangerous to human life. There are certain felonies that are enumerated currently in this bill, and this bill would eliminate the language of any felony clearly dangerous. That language allows us to have a felony that may not be enumerated that can be used for this purpose. Again, it's a tool for prosecutors to help in the prosecution of people who break the law and kill people. So, ladies and gentlemen, with that is one of the reasons that I'm opposed to this as a DA of Shelby County. I thank you for your time.
I have a question.
Yes, sir. Go ahead, Mr. Tillman.
DA Casey, let me give you a hypothetical scenario. During that same bank robbery, what if the bank teller killed the other wrongdoer? Would they be held accountable? The surviving wrongdoer, would he be charged with the other wrongdoer murder?
Currently, they would, yes, sir. Again, if we can prove they were working in concert, they're going in together to rob a bank, the teller kills myself, Representative Bedsole under that situation could be charged with that, yes, sir.
Right. So in that scenario, who is the true victim?
Well, you know, I guess that's the victim. I guess you could argue the person who got robbed is certainly a victim because we will be prosecuting someone for that robbery. I understand what you're saying, that the person has been deceased and they've kind of paid their debt. But, you know, we see many times when there's maybe an older person or a more experienced person in the criminal world convincing a younger person to get involved in something like this. And that's why we believe that it should stay the way it is so that we can hold those people accountable.
And I understand that, but I think with Representative England bill, I think is more or less speaking to the other wrongdoer, the person who actually participated in the underlying offense, because that person can still be charged with the underlying offense, correct?
With the robbery, yes, sir, but they could not be charged with the
murder.
death of the person who's now dead.
Yes, which
Yes,
makes
sir.
sense in the practical world. When you standing in front of a jury explaining the felony murder rule to someone who really don't understand why is this wrongdoer being
why is it two people went into the bank, robbed, one person is killed by the alleged victim, which I believe is a true victim. Now, all of a sudden, the wrongdoer is the quote-unquote victim, and the person who survived is still being charged with his murder.
I believe it should be that way, Representative.
No, I understand that, but this is why we're trying to clarify and clear that up, because the person who is killed, essentially he'll assume the risk, correct?
Oh, well, I think they do assume the risk, yes, sir, but I don't think that their life has no value either. I don't think that because they made a poor decision that no one should be held accountable for their death. Someone should be held accountable for that person's death.
I understand it, but it just, the practical aspect of it, and you know, we've been in court with this, explaining this rule to a jury is very difficult to wrap their mind around it. Because to me, the other wrongdoer is not escaping any type of punishment because he can still be prosecuted for the underlying offense, which is the robbery. Also, you can also prosecute him for murder if you wanted to, because you stack charges all the time, correct?
We charge what we think is appropriate, yes, sir.
No further questions.
Mr. Robbins?
I have a question. So the way I read the bill, I just want to get your fact pattern that you just gave us. That you and Representative Bedsole, which I know both of y'all are known to do, rob a bank. Y'all go into the bank, you rob the bank, and you're saying that if the teller was killed, you know, the teller gets killed, you can't charge, there can be no murder charge. However, if, let's say, Representative Bedsole was murdered and killed, you're saying that there could be no charge for the murder against you, no charge brought against.
If this law passes, yes, sir.
I don't know, I'm reading the bill, and the way I read it is, it says a person does not commit murder under this subdivision if the person killed was a willing participant in the commission of or attempt to commit the underlying felony. Therefore, if Representative Bedsole was killed in the commencement of the crime, you could still be charged for that murder.
No, so the way I'd read it is that I could not be if this law passes. Currently, I could be.
No, but this says, as long as you are a willing participant, it's line 72. If you are a willing participant, you can still be charged for the murder if that person dies. But your fact pattern, if the clerk was killed, you couldn't be charged for the death of that clerk because they were not a willing participant. But I just want to see if I'm correct.
Yes, sir. Just to make sure we're on the same, on line 71, a person does not commit murder under this subdivision if the person killed was a willing participant in the commission of or attempt to commit the underlying felony. So the way I read that is that, again, Representative Bedsole and I go in. If I was a willing participant, he was a willing participant, one of us gets killed, then the living one of us cannot be charged.
That's the way I read it, too.
Yes,
Exactly.
and I agree.
That's the way I read it, too, Mr. Casey.
Yes, sir.
Yeah.
Yes, sir, Mr. England.
Yeah.
With that, let's have a quick question for you. With that understanding, say two people decided, you know, wild and crazy Bedsole. He talks you in. He talks you into robbing a convenience store. All right. As the plans are being made and things are in motion, you come to your better senses. And during the commission of the act itself, you give evidence that you have now disavowed and you are no longer a part of what's going on. And you're in your, you then decide to contact law enforcement yourself while this is going on. But in the course of that conversation, the clerk ends up shooting him. Can you still be charged with felony murder?
I would say you could, but ultimately, obviously, that's going to be up to, we look at the facts as prosecutors. The last thing I want to do is prosecute someone who's not guilty. So I have to look at the facts. I look at the situation. When you say that person kind of disavowed themselves, what evidence is there that they did? If the evidence is that they had a plan, they go in together, and he just says, oh, halfway through, I decided I didn't want to do it. Well, that may not be enough. But if there's a text message, if he's saying, stop, get out of here, if there's some kind of evidence to that fact, we would certainly take that in consideration.
But that would be after you've been charged with felony murder.
I would argue it's part of the investigation.
But I mean, but technically, as the law is written, somebody who's disavowed the plot, but involved ultimately in the planning, but not the execution of it, can be charged with felony murder. Technically, they could be.
Technically, I believe they could be, yes, sir. But again,
And I'm not, but the point of I think that's the kind of the point of the bill is to acknowledge that there may be a situation where two participants in a crime and one person gets killed when the other person that survives didn't have any plans, ideas, wasn't involved in, didn't want to be involved in what eventually happened, but ultimately being charged with something they didn't have any part in. And I think with the way the language is currently written with felony murder, it could encompass those individuals that, as you, I think we would all acknowledge at some point, you may not want that person to serve or be punished the same way as the other person, but felony murder requires it. So what we're trying to get is, something where we don't ensnare that person that shouldn't be serving the range of punishment in Class A felony because of some unfortunate incident that occurs that they weren't involved with, did not intend for it to happen, and so I think that's where we're headed.
Yes, sir. I'll tell you, Representative England, in my 15 years plus as a prosecutor, I've never seen a case where someone was charged who didn't have anything to do with the planning or the implementation or the action. I can't say it's not possible. I've never done it.
I have actually seen and been a part of a case where it did happen, where somebody was just sitting in a car and did not know that there was going to be a drug dealer or felony murder.
Yes, sir. The only thing I can tell you is that obviously the burden is on the state to prove beyond a reasonable doubt that this person was a part of that murder. But yes, sir.
So, but that's sort of that's the intent behind the bill. And I don't think anybody is trying to create a pathway for someone to not be held accountable for something that they've done. But in order for our criminal justice system to work and be effective, the crime and the punishment have to make sense. And this bill is an effort to do that in certain circumstances. Now, if there's some issues with the way that it's drafted, we've been working, since last year and the year before to try to narrow it down a little bit, and we're still in that process. And so I would love to continue that conversation with you and anybody who's interested in trying to make sure that the appropriate perpetrator gets the penalty they deserve for the actions they were a part of versus actions that they.
Yes, sir. And I think we'd be happy to have those talks with you. I would, it seems this bill may do a little bit more than that in the sense that when it's saying that if someone was a willing participant in that robbery, if one of us is killed, then the other one cannot be charged. And this is when we know they're a willing participant. This bill says if they are a willing participant. So that would be my issue with that.
I'd love to continue that conversation. I appreciate it.
Mr. Faulkner, do you have a question?
Yes, sir.
I did. Mr. Casey, and I think you were touching on it there at the end. There's been a lot of talk about what's underlined in blue here on lines 71 through 74, but I think the bigger question I'm hearing, maybe the greater concern from you and the first person who spoke, was this language that is stricken in on lines 66 and 67 and then 70, where it takes out language or another participant in there, which I think you may have just touched on there at the end of your conversation with Representative England. And then on the next page, murder is a Class B felony now, if it's pursuant to A3. So can you speak to that? I mean, there's been a lot of talk about the blue language and, willing participants and not being charged if the other willing participant killed, but speak to this language that's being stricken
Yes, sir.
your concerns with that.
Be happy to. So as to line 66 that goes into 67, or any other felony clearly dangerous to human life, what we feel is that that would eliminate the ability for prosecutors to charge under a certain felony that may not be enumerated in this list. We believe that that language was included so that there could be a felony that maybe we're not thinking of right now that does fit in that. So again, we feel like that's a tool that allows prosecutors, if there is a felony that would fit, and if it can be proven beyond a reasonable doubt, that's something that we could use. I think Ms. Casey also touched on what you mentioned, what was it, in page 4, regarding the Class Bs. So yes, sir, it reduces the felony murders A's to a B if someone committed a rape in the first degree, forcible rape in the first degree, and this person died. That's a Class B felony now, if this passes. Right now, it's a Class A felony. If this passes, it's a Class B felony. That's something that we would be opposed to as an association. Yes,
Thank
sir.
you, sir.
Yes, sir, Mr. Andrews.
I want to follow along on those questions that Ms. Casey brought up, and since you're here, I wanted to ask.
Yes, sir.
Along those same lines, and I want to make sure I understand this right. So right now, the things we just talked about are sentenced under a Class A felony, and then it's a big difference in a Class B.
Yes, sir.
Under this proposed bill, these things under A3 in this section here, starting on 61, arson, burglary, escape, kidnapping, rape, robbery, sodomy, and even aggregated child abuse would be reduced on that murder part on this charge to a B.
Correct.
Right. So I just want to be sure I understood.
Yes, sir.
Thank you, sir. Appreciate it. Ms. Washington, or Mr. Washington, sorry.
My name is Andre Washington. I'm a longtime native of Alabama who lost his son, Adante Washington, in a tragic act of violence 9 years ago. In February of 2015, my son Adante met with some friends in Millbrook, Alabama for the day, who decided to break into an unoccupied home. This included 15-year-old Lakeith Smith, who was the youngest of the group. A neighbor called the cops when he saw a strange car in the driveway and a group of boys ran to the backyard. I would have done the same thing. The boys was running out of the house when the cops arrived, and in that confusion, my son was shot 3 times in the back of the body by the police and pronounced deceased on the scene. This is the first time in person, public, but this is the first time, the first in-person public statement I've ever made, and I'm doing this in support of this HB 32. My voice has never been heard as that of a victim who has suffered a painful loss. My son lost his life, and now I'm having to sit and watch another son's life be thrown away. Adante's friends involved in the break-ins were held accountable for the burglary and theft, which is understandable. But they were also held accountable for Adante's death. It left my family to deal with the loss of not one child, but 2, as Lakeith Smith is now a young adult behind bars, with his life thrown away because of a burglary he committed at the age of 15 years old. HB 32 would close the loophole and lessen the pain any future families who unfortunately may find themselves in a similar tragic circumstances due to a felony. I am fighting alongside Tina Smith to show that using the felony murder rule to change the co-defendant to charge the co-defendant with the death of another co-defendant is not what the families of victims want, and to make sure that this doesn't happen to other parents in the community. I ask that as a father who has suffered loss, you finally let my voice be heard. I ask you vote yes on HB 32. Thank you.
Thank you, Mr. Washington. Okay, thank you, sir. Mr. Robinson.
Thank you, sir. My name is C.J. Robinson. I am the district attorney for the 19th Judicial Circuit for Chilton, Watauga, and Elmore counties. And this morning, I'll take a few minutes and address some things. It might be somewhat cycling back to some of the questions I've already heard, but I'll start out by saying this. I've got two children, a 4-year-old and a 6-year-old. So this is my 3rd year of coaching 6-year-old or under girls in softball, and my 1st year of coaching 4-year-olds and around that age in baseball. And I find myself every breath at practice and games saying, keep your eye on the ball. Stay focused. Keep your eye on the ball. That's a little bit what I want to try to do this morning, to try to bring this into focus a little bit. The case that you've heard about some involving Mr. Smith, no one should know more about that case than me. It was my case. In 2015, I had a meeting with the district attorney at that time, Randall Houston, and I made the decision to charge felony murder against Lakeith Smith and the other individuals charged with that crime. And let me tell you why, because I hope my words today, I'm going to be as brief as possible, will make sense of why we did that. Now, I grew up in my grandmother's house. My mother was in college and things, working her way and through school, and so she was a real big proponent of Paul Harvey. So the rest of the story sometimes helps make sense of what happened. So you heard about February of 2015. Let me tell you about February of 2015. So in Montgomery, there was a young man named Brandon Brown who was murdered. That happened on February the 21st. Several individuals involved in this case was involved with that murder of that young man, including Lakeith Smith and Jadarian Hardy. The next day, at the Big Boys Club in Montgomery, there was a confrontation with a young man from Crenshaw County. He was held at gunpoint. He was made to strip off his clothes, his car was stolen, and he was shot. He was shot with stolen firearms. The car that was stolen that he was driving was the car that was used to drive to Elmore County into Millbrook just a few hours later, when these young men who were armed started breaking into houses. The first house they broke into, they stole things. The second house they broke into was when the police responded. The police did not respond and just start shooting. That case was investigated by Aaliyah. There were multiple agents that processed that case. I presented that case to a grand jury, and a grand jury found that that officer acted properly under Alabama law using deadly force. Now, there's diagrams that I'd be happy to supply if I need to, showing the projectile rounds that were fired at the officer from 2 different young men, from Javarsky Jackson and also from Mr. Washington. The officer, I believe, fired 2 rounds back, kind of in this setting, as Mr. Washington ran through the fence. As he's coming around the outside of the house, there's another Millbrook officer who encounters him. There is body cam footage. That body cam footage was entered into evidence. That was the basis of a federal lawsuit. So that footage is there. And so you see the officer as he's approaching, as Mr. Washington is running towards him with gun in hand. He does shoot. I believe he shoots 3 or 4 times. He immediately holsters his weapon, drops down on his knees, and starts performing CPR and calling for medical assistance to Mr. Washington, who was shot. Now, that's kind of a little bit of the rest of the factual scenario of the case we were talking about. The individuals involved, Lee Anthony Washington was charged with felony murder, burglary first, theft first, and theft second, as were everybody involved, with Javarsky Jackson having an additional charge of attempted murder for firing the weapon at the officer. Why do I tell you that? I tell you that because we made offers in that case. Lee Anthony Washington pled to 17 years. He was the first person who took responsibility and said, this is what we did, we were wrong, and I'm willing to answer for it. Jadarian Hardy, he pled to 20 years. Javarsky Jackson pled to 28 years. That was a higher sentence recommendation because of his firing the gun at the officer. Lakeith Smith, he had a trial. He was given a plea offer in accordance with everyone else. He did have a trial. Now, at the conclusion of that trial, the judge did sentence him to 65 years. That was a sentence way higher. That was way more than we asked in the sentencing hearing for a recommendation. There's been a Rule 32 filed, post-conviction relief. I consented, as the DA at that point, I consented that defense counsel was ineffective. and we had a resentencing hearing. That sentence was reduced from 65 years to 30 years. I did not fight that resentencing hearing. So I hear the different things being said here, but I made a decision in 2015, and sometimes we make decisions and we look in the mirror and we have to realize, did we do the right thing? Well, I believe I did, because as said earlier, when you start talking about if the teller had died or if this person died, you start wondering, should there be accountability? And if you're a willing participant, if in this situation here, I felt in 2015, this is years before a lot of this stuff got brought to light, I felt that we were minimizing the value on human life of Mr. Washington if we did not try to pursue that charge. Now, with that being said, it's different. We have a, yes, sir.
You've gone a little bit over your 3 minutes.
I apologize.
But can you sum it up pretty quick?
Yes, sir. You mentioned that about the victim. I would say the victim is the state of Alabama. I think that there's times to where we have a responsibility to try to look at a situation and say, even though this is not normal, I still think we have a responsibility. We had one case in Elmore County out of a prison that revolved around distribution. It involved in a high-speed chase. There was like a 4-month-old in the back seat. The car does a Smokey and the Bandit into the river and someone dies. We charged a felony murder in that situation. Thank you.
Mr. Robinson, thanks. Yes, sir, Mr. Tillman.
I know you mentioned the victim in the case. So during the case, did you treat Mr. Washington as a victim?
You talking about on the felony murder case? I mean, he was listed in the indictment as a victim. As far as asking his family what was their wishes, no, I did not do that.
Isn't it typically that's what the district attorney office does in those situations, is talk to the victims, correct?
It's not their case, but we do typically get their input unless I know that the victim is contrary to our position. And I have done that before, like in a child sex case where a mother will say, I'm still going to stay with the person who raped my child because I love him. I'm going to discount her wishes and we're going to prosecute the case anyway. So that was kind of the mindset taken.
No question.
Thank you, sir. Appreciate it. Thank you, sir. This concludes this particular public hearing on HB 32. We thank each and every one of you for coming. HB 165, Mr. Brown. Just tell us briefly about your bill, and then we got two folks, one who want to speak in favor and one opposed. But go ahead.
Thank you, Mr. Chairman. Members, this is House Bill 165, and what this does is, since 1973, the age of medical consent in Alabama has been 14 years old. And, as a 14-year-old, you can't drive, you can't join the Army, you can't legally buy tobacco, you can't, you can't vote, you can't do most things without your parents' consent. But under the current law, you can go down and get a vaccine, no matter what that is. So what this is, it's not an anti-vaccine bill, it's a parental rights bill. And what this does, it just says that parents have to consent to a child having a vaccination, no matter what it is. It's a written consent. Many doctors across Alabama do this currently. I actually worked with doctors in the language. It took me 2 years to put this 2-page piece of legislation together, but I wanted it to be right and done properly. That's where we are. I just believe that parents should have the right to consent to their children getting medical care.
Okay, thank you, sir.
Yes, sir.
Ms. LaPointe, you asked to speak in favor of this. Terry LaPointe, please come up, ma'am.
My name is Terry LaPointe, and I'm a parent, and I am a family advocate, and I was also a investigative reporter for medicalkidnap.com, which also worked a lot with vaccineimpact.com, and I've seen many stories of consequences that the parents didn't have any idea were coming. So one thing that we need to remember is that we legally there is legal immunity for the vaccine manufacturers. And there are risks with vaccines, as we saw with the myocarditis in the young boys, especially the young men with the COVID vaccine. There are risks. And as an adult, we can decide whether the benefits or the risk, we make that choice. But as a parent, we're responsible for our children. That is our primary duty, is to be responsible for our children. And So there are so many new vaccines on the horizon, and with this immunity that the vaccine manufacturers have, we as parents need to be able to make those decisions. And as the gentleman said, children, they're not looking at the pros and cons. They're 14 or 15, and they're not making mature decisions sometimes. Sometimes they'll do something because they're being rebellious. But the parents have the responsibility. And what if a child gets a vaccine and the parent doesn't even know it, and there's a response and they have an injury and the parent has no idea what's going on because they didn't consent? That wasn't something that they said gave permission for their child. So I applaud this bill, and I hope that you will pass it for parental rights.
Thank you, ma'am. Thank you very much. Mr. Champion.
Thank you, Mr. Chairman, members of the committee. My name's Graham Excuse me. My name's Graham Champion. I represent the Alabama chapter of the American Academy of Pediatrics. Pediatricians in the state are opposed to this legislation. They regularly have adolescents that will come into their office 16 years old that now can consent to medical treatment, can consent to other things. There are times that someone who is not a parent or a guardian brings a child into a pediatrician's office, and they may be another family member, may be a close friend, but they are bringing them to the doctor's office for a regular checkup. And to say that because they're not a parent or a legal guardian that they can't consent causes a problem. The other thing is that any adolescent age 14 or older who is treated under a Title X program, which is family planning, reproductive health, other things of that nature, the federal law is age of consent is 14, and Title X specifically says that law may not be amended by state law. That being the case, if this legislation is passed, we'll have two different classes of adolescents: those that can give their own consent and those that can't. I believe, and I'm not an attorney, but I believe under the basic tenets, as I understand it, of the equal protection part under the U.S. Constitution, this could cause a violation and put the state in a position once again, of the state being sued for a violation of the constitutional rights of individuals. Thank you very much. I urge you to vote no on this legislation.
Thank you, sir.
I have a question.
Yes, sir.
Mr. Champion, why, I mean, I get the scenario when you say someone is going in for something medical and they're 14, 15, 16, and they're not with their parent or legal guardian. But why wouldn't that be more of an exception? Why would we not want a parent or legal guardian to be signing off on a medical procedure, medical treatment of a minor? Why would we not want to have that and make it an exception if that's not available for some reason? Do you see what I'm saying? I'm stepping back.
Representative Faulkner, I certainly understand what you're saying. I think it's more the exception than the rule that you would have somebody that's 14 that comes in by themselves.
Right. I agree.
But a 16-year-old, a 17-year-old that's driving, we've got a doctor's appointment after school. I'm going to swing by after school, go see the doctor for a regular checkup. I've been getting flu vaccines my whole life. It's the fall. Physician says, time for your flu vaccine. I'm 16 years old. I say, okay, I've always gotten them in the past. Why shouldn't I be able to get it?
Well, it sounds like you're making a good argument for me to move the age to 16. I mean, in other words, I would think we would want as much as possible, the consent of a parent or legal guardian for medical procedures. I don't understand why this is the way it is. Why is it? What's the big impetus to not have that for a 14 and 15-year-old, for example?
Well, I think one part of it is conforming it to what federal law is.
Or do we know why federal law, they picked 14?
I have no idea why federal law is what it is. But I mean, I think it's obviously been there since I believe Mr. Brown said the early 70s. I don't know what the reasoning was behind it then, but it's been the law for 50 years. As much as we can, and I think we've done it in tax law and other things where we try to have conformity between state and federal law. And, this is existing law. We're not trying to change it to 14.
Correct. That's why I'm stepping back and asking why we would not want to have, and then make exceptions where we need to, but we would want to have parental, I would think, for a minor getting medical treatment.
I would agree that under the general conditions, you would hope to have the parental consent and involvement in it. But I don't know how you can write into legislation every possible exception that might come up.
And we never do that, yeah. But we, you don't throw out everything just for the possible exceptions either, So anyway, thank you.
As I said, the pediatricians are opposed to it, but I think the bigger question in one respect is the conflict between federal law and what we're trying to do with state law.
No, Ms. Graham. Mr. Robbins, you have a question?
I think Representative Faulkner kind of asked my question on his second part there. So the federal law does not provide for extenuating circumstances to treat a 14-year-old, or you can just treat a 14-year-old without.
14-year-old has the right of absolute medical consent, and it cannot be amended by state law. Those are not my words, Mr. Robbins.
Mr. Simpson.
I echo what Representative Faulkner has indicated as part of my concern with this. Look, I think we're all learning this culture that we're in now with vaccinations and how things go. As someone with an 11-year-old daughter, this stuff scares the hell out of me, to be blunt with you. But there are times when I have to get a family member to take my daughter to the doctor. We have a family. My wife works, I work. Sometimes I have to get my mother to take my daughter to the doctor. Sometimes there's a lot of vaccinations of, hey, it's time for this vaccination. And there's a lot of things that go on with young girls that I'm learning the vaccination process, especially with how they have to go through. I don't understand why we wouldn't want parental guidance on some of these issues. I just, that fundamental question of why we're arguing and saying a 14-year-old doesn't need parental guidance to worry about their vaccinations, it just absolutely scares me to death.
Mr. England? Oh, wait a minute. Hold. Mr. Wadsworth, you had something.
I just had a question. As far as the definition of vaccine, but what is the definition of vaccine?
I don't know the legal definition of it. I can get it for you.
If a client goes to a doctor to be treated for something, do they ever give him something that would be a booster to help him with any other medication they're taking?
I would assume that yes, they do.
And would this bill prevent them from being able to give them that additional booster if they went in less than 16 years of age?
Less than 18?
Yeah.
Yes, sir.
And would that then necessitate them having to go back again for additional treatment?
If a parent or legal guardian wasn't there, yes.
Okay, that's all.
Mr. England, do you have a question?
I swear I'm getting confused here. So there's in Alabama, you can be an emancipated minor, and is there like a age limit on that? Is it, I might be asking the wrong person, but I mean, if you're emancipated, you can make your own decisions in terms of vaccines and so forth.
If you're emancipated, it's my understanding you can basically do anything that an adult does.
Right. So the bill says if you're 14, you would have to get your parents' consent before somebody else vaccinates them?
That's correct.
So I'm trying to figure out your opposition. Is it because of the federal law?
No, the age of 14 for medical consent has been Alabama law, I believe, for over 50 years, if I've understood Representative right. So I don't know I don't know when the federal law came into being, but currently, under Title 10, age of consent is 14, and it says you may not amend it by state law.
All right, I guess I'm trying to figure out, you're against it.
We're against changing it from 14 to 18.
Okay.
Robbins, did you have a question?
So,
okay,
never mind.
Go ahead.
I think I'm
That's an interesting revelation on your part, but I hope we got it on the record somewhere. Go ahead, Mr. Robbins.
Yeah, I'm just kind of perplexed by all this too, because that means like totally unrelated, but like all these bills we've debated around here with transgender care and all that. So what you're saying is a minor at 14 could just go and start doing that without any oversight according to federal law.
According to federal law, as I understand it, yes. That said, the transgender treatment process in Alabama prior to the legislation passed last year, it was a common practice at UAB and Children's, which was the only place in the state that any treatment was being given.
But I'm just saying that, so you're saying that, this is flabbergasted me, that at 14 you can go do any kind of medical treatment you want to without any parental consent. And you don't even have to inform the parent. So it's not as a matter of, I give this treatment and I'll tell the parent, hey, I did this treatment so you know your child took this medicine today, or we gave them this shot. You could keep all that secret away from the parents, so the parents have no knowledge of the health care that their child is receiving.
Mr. Robbins, when my stepson was 15, he was going to see an adolescent psychiatrist for mental health issues, was going in for regular treatment and consultation. When I asked the psychiatrist, was there anything that we needed to know? The response was, he's over 14 years old. I can't tell you. I'm bound by doctor-patient confidentiality.
Right.
And I said, I'm paying for it. They said, doesn't matter.
Right. I understand that in terms of mental health and counseling scenarios, but I'm just thinking, I mean, we're kind of belaboring this point, but just if I gave you some sort of medicine today, or I gave, your child received some sort of treatment, they had this issue, it just seems as if a parent should have knowledge that their child even received that care.
Okay, I cut this off, folks. It's a public hearing. We go back in session at 4. I know we got stuff to do here today. That's why we have public hearings. This gives y'all 2 weeks to think about this and do all the research in the world that you want to, and I want you to, and I look forward to this debate in 2 weeks. But I know that once the House goes back into session, our committee is over for today, and I want to finish some of these bills that I'm looking at. So, Mr. Graham, thank you. Senator Coleman.
Thank you.
Senate Bill 18. Go ahead, Ms. Coleman.
Thank you. so much, Mr. Chair. We actually go in at three, so I appreciate this opportunity to come before you all. Senate Bill 18 is not really new to this committee, except for the new members. I've had this bill several years in a different version of it, and we have Senate Bill 19, which is the larger version of being able to increase the statute of limitation to be able to help those survivors of child sex assault. This particular bill is specifically for those boys that had to endure trauma in the Boy Scouts. And so there is a national Boy Scout trust settlement fund. If we don't pass this piece of legislation, the nearly 1,500 to 2,000 survivors in the state of Alabama won't have the opportunity to fully get the amount that they deserve through the fund. And so we're on a kind of a time, we have a really issue when it comes to time. We passed this bill unanimously in the Senate. Representative Simpson is going to handle it here in the House for me on the floor. And so if there are no further questions, I forget that I'm not on the committee I was getting ready to ask for. The passage of...
I'll do it for you. Is there
thank
questions?
you.
Move to give the bill a favorable report.
Second.
All right. Y'all understand, does anybody have any questions for Senator Coleman about this bill?
We also have Stuart Vance here today, Mr. Chair, who is with the Survivors Group, in addition to Graham Champion, who just spoke, is representing the Boy Scouts also, and mentioned that, of course, they're not in opposition to this bill.
Okay, thanks. There's a motion, there's a second to give this bill a favorable report. Seeing no more questions, all in favor say aye. Aye. Any opposed? Senator Coleman, it's good to see you back here.
Good to be back, and thank y'all so much. We're going to be able to help some folks with this piece of legislation. Thank you.
Ma'am. Representative Underwood, how about 222?
Thank you, Mr. Chair, for the recognition. Thank you, committee members, for having me here today. This is House Bill number 222, which we believe close a loophole that really otherwise you're just not aware of until a situation specific occurs, which did in my district. Basically, it says that there will be no sex offender, adult or juvenile that will accept or maintain employment or as a volunteer, which is where the loophole was, as a first responder, and then it defines what positions those first responders are. And we believe this just kind of prevents the person from being in a situation where they're precluded from being from in the first place. When called to a certain situation that may put them in a place they shouldn't be by law. And so this just kind of closes a loop on that. And I have vetted this against him with the Association of Volunteer Firefighters, as well as the Association of Rescue Squads, which the Green Jackets have my back here today, knowing that we have vetted this bill with both of them, and they both are in approval of it. So
we have an amendment to this bill, do we not?
We do have an amendment.
Who's offered it?
Representative Bolton.
Oh, he's not a member of the committee.
No, sir.
No, sir.
No, sir. No.
Hey, I have two amendments.
No, but one of them one of them was mine, I'm not going to offer it. So we got one amendment.
Got you. My apologies.
Tell you what, I'll offer it for you. What this First Amendment does is simply does not subject the fire entity, the firefighters or the volunteer fire department to any liability. Isn't that pretty much what this does?
That's correct. It was implied, and this makes it explicit, which is better. No responsibility to the departments.
All right. Is there a motion that we amend this the bill? So moved. Thanks. Is there any questions? Y'all understand? It just doesn't. It exempts the entity from any type of potential liability, and it should be.
Right. They shouldn't be doing background checks.
They should be exempt from that. They shouldn't be liable.
That's correct.
All right. We got a motion to amend. Is there a second? Second. All in favor? Okay. Any opposed? Your bill is amended. I'm not going to offer the other amendment I was thinking about, Mr. Underwood. We're fine. So your bill is back to you as amended. Are there any questions on the bill as amended? Yes, sir, Mr. Simpson. Okay, thanks. There's a motion for a favorable report and a second. All in favor say aye. Aye. Any opposed? Thanks a lot, Mr. Coleman.
Thank you.
Mr. Underwood, we appreciate favorable report as amended. And Mr. Simpson, please go ahead and let me steal a little of his thunder. We're happy to have Judge Honeycutt here with us today. Judge Honeycutt, I think you're from Mobile, is that correct? Yes, and we are glad to have you with us. Mr. Simpson, Why don't you talk about 136?
I think the best way I can let the committee understand the gravity of what we're trying to do and why we're trying to do this bill is if I can have Judge Honeycutt tell his story about what happened.
All right. Go ahead, Mr. Honeycutt. So, Judge Honeycutt, I'm sorry.
That's quite all right. All right. My name is Walter Honeycutt. I'm a circuit judge in Mobile, Alabama. I'm actually the presiding domestic relations judge there. Back in September of this past year, a very tragic scenario happened in my court, and it's still emotional, very, very emotional. Okay. Two children, two small children, a 5-year-old and a 3-year-old, were brutally murdered by their mother. 3 days prior to that, they were in my courtroom. I had a mother who's completely insane. She had gone to the local women's shelter, which is Penelope House. The first person I've ever known to be kicked out of Penelope House because of her mental illness. She was making unbelievable allegations against the father, sexual allegations about molesting the children. Here I am, a divorce judge. My choice is to give either the mother the custody or the father the custody. I can't do either one. I can't order DHR to go get those children because I don't have jurisdiction. Only the juvenile court can do that. So we're trying to do this, trying to figure it out. I'm no longer get my position from the DHR, but they were involved. We were trying our best to see what was best for these children. And prior to them even getting out there to see the children or get the children, Mama kills both of them, then hangs herself. Now, this was devastating to my entire staff, to me, to lawyers, that I couldn't do anything for those two children. Hurts, and still hurts. So the legislation is, I asked Matt to do, help us out, please. Do something, please. Give me jurisdiction, please. Do something to where if this scenario ever happens again, a judge, such as myself, can say, please, somebody grab these children before something happens. I'm talking about immediate harm, immediate death, immediate bodily injury to these two small children. And that was the emphasis behind this. Now, I don't write legislation. Matt did. I don't know if it's right. I don't know if it's wrong. I'm just here to tell you, please help me save these two children. I can't save these children. They're dead.
The next two. The next two is the ones you're worried about, isn't it, Judge?
Yes.
That's what I thought.
This scenario may happen, may not happen. It may happen, may never happen again.
Am I right in saying that this bill allows a circuit judge to have that jurisdiction to do an ex parte order, not necessarily just in the context of a divorce action, but any other action? Is that correct?
I think that's the way it's written. Again, I'm not a legislature. I don't know how to draft.
How do you get it from circuit court? Do you retain jurisdiction over this case the entire time, or does it at some point get transferred to juvenile court, and is there a mechanism to get it transferred?
Yeah, that's what we're trying to fix, is that in a divorce case, in the way the law is written right now, juvenile court, circuit court are mutually exclusive. I have no jurisdiction to tell a juvenile judge what to do, and he has no jurisdiction to tell me what to do.
But if this bill passes, would you have the authority then to transfer it to juvenile court?
The scenario of the custody of those children is under an emergency order, transfer it out to juvenile, and they would have to have a hearing within 72 hours.
Okay.
And that's the emphasis as I understand.
I think it's a good bill, and I appreciate that.
I'd move to give the bill a fair report.
Hang on. Hang on just a second. Mr. Simpson.
Here's where we are with this. You guys understand the reason and the rationale and the rhyme of what we're trying to do. There may be some unintended consequences right now with the bill as it is drafted. I've met with DHR. What we're trying to do is to eliminate some of those unintended consequences as far as state long-term costs for the children. I do think that I want to make sure that the body is aware. My purpose of doing this is to make sure that the emergency ex parte order can be issued. I'm not looking for long-term, now this judge is responsible for the children for the rest of their lives or any of that stuff. Judge Honeycutt had an open in his schedule today, so I asked him to come up here and speak to the committee so you guys can fully understand what we're doing. I would like to be able to get some time next week to work on this before we come back the week after, to make sure that we get the language right of what we're trying to do without changing the spirit of the bill to give the emergency ex parte order to the judge.
Appreciate it, Mr. Simpson. With that, I'm sort of going to take that as a request on your behalf to carry this over till our first meeting after the break.
Till the first meeting after the break.
You will be back on 136. We'll be back on. Judge Honeycutt, thank you for coming. We appreciate you sharing with us a lot. All right, Mr. Chestnut, Representative Chestnut, how about 1-7? We got a few minutes. We got one.
Have to go there.
You can stay right up here, Mr. Chestnut.
Okay, HB 172. This is, I guess, in a short form, the deepfake bill. And essentially what this bill does is, because of the emerging technology with artificial intelligence, it can be used to alter the outcome of elections. And so this is what this is intended to do, to create some level of accountability for candidates who enter into these elections and who attempt to change the outcome of an election by engaging in some using a deep fake generated through artificial intelligence to do so. Before I move forward, there's actually an amendment.
Offer your amendment, Mr. Chestnut.
Okay. This amendment, if you go to line number 49 on page number 2 of the bill. Okay, we see on page number 2, under the definition of artificial intelligence, it says any artificial system, okay? And with the amendment, it's going to say any artificial system or generative artificial intelligence system that performs tasks under varying and unpredictable circumstances without a significant human oversight, or that can learn from experience and improve performance when exposed to data sets. So that is the first, that's going to be the first part to this amendment. And then the second part to this amendment will be, turn to page number 5. On page number 5, if you look at line number 121. So what I'll do is I'll start at 119, where it says a violation of this section is a Class A misdemeanor, except that a second or subsequent conviction within 5 years is a Class D felony. So this is where we would do the insertion. Insertion would take place there. And we would say, we would add subsection D1, distribution of material that's prohibited by this section shall not be a violation of this section if the distributing entity or any employee or agent or a distributing entity does not have actual knowledge that the material is prohibited, and a distributing entity is a radio or television broadcasting station, including but not limited to cable or satellite television operator, regularly published newspaper, magazine, or other periodical, including but not limited to an internet or electronic publication programmer or producer, a website or streaming service, including but not limited to an information service that's defined in 47 United States Code, section 153. This act shall not be construed to alter any rights, obligations, or immunities created by Title 47 U.S.C. Chapter 5 or under the rules or regulations of the Federal Communications Commission pertaining to the broadcast of political programming or campaign advertising, or under any other federal law. So that is the amendment, and I'd like to offer that.
Is there a second to the amendment? Thanks. Any questions on the amendment? And all in favor of adopting the amendment, please say aye. Aye. Any opposed? Okay, Mr. Chestnut, back to you as amended.
Okay, with that, I would like to take any questions or ask to move for a favorable report.
I'll let that, was that okay? It's a second, Mr. England? Second, okay. Motion second to give this bill a favorable report as amended. Any questions? Yes, sir. Mr. Sanders, please.
I just have a question for the sponsor. I know we're talking about mainly artificial intelligence, and we're all sensitive to that issue, you know, on the campaigns and everything. Does it also, you know, some of these things that are deceptive are not artificial intelligence. They're done by computer, you know, cut and paste and, you know, all that. Does this bill affect those?
This one is kind of, I guess, is probably a little more narrow in scope than what you're talking about, because we specifically are, you know, targeting like dealing with artificial intelligence. Yeah.
I'm just saying that's an issue too. You know that.
You're correct.
Photographs and stuff can be manipulated. That's not artificial intelligence, or video maybe. But anyway, it's something to think about as the bill moves forward.
Yeah, but I think but a lot of times you're probably gonna, to make it look realistic, probably do need artificial intelligence to do that. I know what you're talking about, like sometimes how people will they kind of they're really good at being able to take something and kind of, but I mean, the effort is a lot greater, I think, under those circumstances versus the artificial intelligence, which is you just kind of programming into it something that you desire, and then it kind of creates the image from data sets. So,
I mean, I definitely understand what you're doing. I think that the issue's a little bigger sometimes, you know, as far as putting someone's depiction in a scene that they wasn't actually at, or, you know what I mean, something that's not necessarily artificial intelligence. But anyway.
I got you.
Standards, thanks. Any other questions? Then I've got a motion and a second to give this bill a favorable report as amended. All in favor, please say aye.
Aye.
Any opposed? Okay. Mr. Chestnut, favorable report is amended. Representative England, how about House Bill 200? Why don't you stay where you are?
Won't take but a second. We've been working on it. I've got actually an amendment to the bill that was offered by, but we're not going to judge the director of forensic sciences, Mr. Delamana, has had some issues, so he's been trying to help be involved in crafting this legislation, and he was unable to be here today, and he's been indisposed these last few weeks. So we're just going to carry it over until we come back, so we'll give him an opportunity to recover, and then we'll have more discussions about this legislation.
That's fine. Thanks, Mr. England. I appreciate it. We're slowly filling up our agenda for 2 weeks, aren't we? And that's okay. That's the way it works. Yes, sir. I know, Mr. England. I've read them. Okay. Representative Alban, if you just stay where you are, please, ma'am, and tell us about 226.
Yes, sir. Thank you very much. HB 226, the whole purpose of this bill, this short little bill, is to clarify what's really an ambiguity right now in the law. How these things stay this way for so long, I don't know. But currently, if someone wants to appeal a decision from the Board of Adjustment, they have 15 days to file their notice of appeal. But there is no time limit by which they actually have to file their appeal. And what happens is they often will give, or sometimes will give notice of the appeal, but will not actually follow through with the actual appeal. So it puts this municipality in between a rock and a hard place, because they cannot enforce the decision that the Board of Adjustment, they cannot move forward because the person has not moved forward with their appeal, and they get stuck. And so the whole point of this bill is to clean that up a little bit. Everything is exactly the same. We still have 15 days to file your notice of appeal. Then you have 30 days to actually file the appeal with the proper circuit court. And then there's certain timelines that the city has to get the proper information to the circuit court. And there is also one amendment that we'll need to offer.
Okay, ma'am, go ahead and talk about your amendment.
Amendment, just replace lines 63 through 64 on page 3 with the following: action in the circuit court shall be tried de novo. All that means is, as it's written, it would just be a bench trial by the judge, and this would allow the option to be a bench trial or jury trial.
Okay, and that's a motion, that is a motion to amend. Is there a second?
Second.
Thanks. There's a motion, second. Any questions on the amendment? Okay.
I was wondering if Prince could read it with the bill.
No. Okay. There's a motion to amend. All in favor of amending this bill, please say aye.
Aye.
All right, Ms. Almond, it's back to you, and I think Mr. Wadsworth has a question.
Representative Almond, is the issue that they file their notice of appeal with the board, but then they don't take any action to file something in circuit court?
Correct.
And this just gives that deadline of 30 days?
Correct.
And is it 30 days from the notice, or 30 days from when they file that notice of appeal?
Thereafter, the aggrieved party must file the appeal with the proper circuit court within 30 days of the final decision of the board.
What is the trial de novo? What is the current state of the law about trial de novo?
In terms of this particular
Yeah, I know this adds a trial de novo with it, but
the current law, it says tried de novo also. On line 47 here, if you see that stricken through.
So it's really not changing that.
No, it's keeping it the same.
It's just setting up a timeline for filing the notice of appeal and filing the actual action in circuit court.
That's correct.
Okay, thank you.
Thank you.
Okay, we now have have we gotten a motion for favorable report of the meeting? Mr. Simpson?
So moved.
Thanks. Is there a second? Thank you, Mr. Tillman. Okay, there's a motion and a second. Give the bill a favorable report as amended. Any questions? All in favor, say aye.
Aye.
Any opposed? Thank you, Ms. Almond.
Thank
Appreciate
you.
it. Ladies and gentlemen, that concludes our meeting. We appreciate y'all being here. We're off next week, so we will see all of y'all in 2 weeks. Thank you for coming. Holy cow.